They set up their own practice. Over a decade now, members of the jury, she has practiced at Cooperman and Jones. She has learned and developed a reputation of a skilled, ethical, fair, and hard-working worker. Her firm has grown from a firm of 2 lawyers to now a firm of over 30 professionals. I expect that Ms. Cooperman will get up and testify that it was on September 8th that the seeds of this very lawsuit was sown. Ms. Cooperman agreed to offer her services to Mr. Engels to try and help him with his legal problems, only to now find that this ex-client of hers unhappy with the settlement that he agreed to set his sights upon Ms. Cooperman, looking for more money. Now, I anticipate Ms. Cooperman will relate to you how she met with Ms. Mary Rubens and Mr. Engels that morning, and how she listened to their problems, how she gave her best legal advice, and how she had them sign a contract, a fee agreement. And that fee agreement will be before you in evidence. And no doubt you will want to pay close attention to that fee agreement, because I anticipate this agreement will show that in the very body of that fee agreement, there is an express waiver of any conflict between Mary Rubens and David Engels. But even before David Engels and Ms. Rubens met Harriet Cooperman, you will hear from Pat Simpson. Pat Simpson conducts the initial interview with potential clients and did so with Ms. Rubens and Mr. Engels, even before Harriet Cooperman met them to conduct the in-depth interview later on that day. You will hear that Pat Simpson is an experienced paralegal and a competent one. And she will tell you about some of the office procedures put in place that she must follow in each and every case. Now, Ms. Simpson will tell you that she conducted that preliminary interview with Mary Rubens and Mr. Engels in line with the office policy and procedures. She will tell you that after receiving some information, basic information, she learned who the defendant or potential defendant was in this case, which was Acme Corporation. I expect her to tell you that she conducted a conflicts check with their computer system, just to ensure that Harriet Cooperman was not going to represent Mr. Engels against a current client of theirs, Acme Corporation. Ms. Simpson will tell you she exercised her due diligence, and Acme Corporation was not a current client. Now, members of the jury, you will hear that Acme Corporation used to be a client of Cooperman and Jones, but that the evidence will show, and you will hear expert opinion evidence as well, that dealt with an unrelated matter that was several years old. Now, members of the jury, you will also hear Ms. Cooperman get up and testify and candidly admit to you that Cooperman and Jones have since changed that policy and that conflicts check. The computer system now detects past clients for 5 years from the date of the new client, not just simply current clients. And indeed, members of the jury, Ms. Cooperman will get up and candidly admit to you that they changed that policy and practice because of this very lawsuit And not because there was an actual conflict of interest. Rather, Ms. Cooperman will tell you, it is because the firm does not need the expense, the inconvenience, and the hassle of being drawn into disputes like this, where a disgruntled ex-client brings the firm into this lawsuit. That's 7 minutes. Thank you very much.
Thank you, sir. So now, members of the jury, having heard the evidence in this case, if you're liking to speak, we'll advance to the end of the trial, and we'll now hear the closing arguments from counsel to the parties. And first of all, on the defendant, counsel to the defendant, Ms. Parker. Yeah, thank you. Yeah, thank you, counsel. Counsel to the plaintiff, yes, Ms. Parker.
In the last 4 years, David Engels has been badly hurt twice. First, he was hurt when the car he was riding in was sideswiped by an Acme truck. And second, he was hurt when his lawyer, Harriet Cooperman, talked him into settling his lawsuit against Acme for about half of what it was really worth. How do we know the lawsuit that he settled was only settled for half of what it was really worth? Because Acme's lawyer says so. The lawyer for the defendant said so in his evidence. It's not the opinion of an expert who we hired to come and testify before you in this case. It was the opinion of the lawyer who represented Acme against David Engels. James Doran told you that he'd expected to settle the case for $175,000 to $200,000, not the $100,000 that Ms. Cooperman recommended. Lawyers and clients have a special relationship. All lawyers have a duty towards their clients. David Engels put his trust in Ms. Cooperman. You heard about his injuries. You heard about his losses. He was vulnerable. But he was also vulnerable because he needed his lawyer to help him understand what to do and how to do it. He needed his lawyer to guide him through the process of the lawsuit. And when Ms. Cooperman agreed to represent him, she promised, like all lawyers do, to protect him and to act in a way that only advanced his best interest. So why would she agree to settle a lawsuit for half what it was really worth? Because she hadn't done her job, and she knew she was about to get caught. And if she had, she would have lost her fee. Acme's lawyer, James Doran, brought a motion to have the judge remove Ms. Cooperman from the case because her law firm, Cooperman and Jones, used to represent Acme, the very same company they were now suing. Does that seem right to you? You heard evidence from expert witnesses explaining to you that in the world of law and legal rules it's not right. But you probably didn't even need to hear that evidence to know what it seems to you, how it makes you feel in your gut when you learn that. Because if the judge didn't qualify Ms. Cooperman from acting for Mr. Engels, then Mr. Engels testified he would have fired her. He never would have agreed to have her continue to represent him if he had known that her law firm used to represent the very same company that he was now suing. He never would have agreed to have her continue to represent him had he known she'd taken opposing counsel as her lover while the case was still pending. I mean, can you blame him? But did Ms. Cooperman tell any of this to Mr. Engels? No. No, she didn't. Better to sell him short than to lose her fee or expose her mistakes, expose her errors, expose herself. wasn't such a good choice. Expose her negligence, huh? In fact, between the day they met and the day she recommended he settle his case, Ms. Cooperman only spoke to Mr. Engels 4 times. Now remember, and when you go into the jury room, have a look at that bill she sent him. He paid her $33,000. That's $8,250 a meeting. Now you might be thinking that's hardly fair. Ms. Cooperman said she settled the case for 2 reasons. 1, because she only learned for the first time at the examinations for discovery that Mary Rubin was partly responsible for the accident. That would have reduced the damages Mr. Engels could get, she told you. And 2, because her client did such a bad job at the examinations for discovery. That motion for Acme's lawyer to get me off the case had nothing to do with it, she told you. Nothing at all. Did you believe her? And if it were true, wouldn't she have mentioned settling after the discoveries? If it were true, wouldn't she have told her client about the motion? Ask yourselves, is it a coincidence that it was only after Acme's lawyers filed a motion to have her removed from the case that she wanted to talk settlement? But what about those examinations for discovery? Did Mr. Engels perform poorly? You bet he did. To use his own words, he was a nervous wreck and he came across horribly. But why? Part of the job of a lawyer is to prepare her client to testify. And Ms. Cooperman utterly failed to prepare Mr. Engels for those examinations. She didn't meet with him in advance of the examinations. She didn't visit the examiner's office with him. She didn't conduct a mock examination to give him a sense of what it would feel like. No. The sum total of her preparation was crammed into 1 short hour the morning of the examinations. It was only the 2nd time she had spoken to him. She yelled at him during that hour. During the examinations, she took a break to take him into the hall and yell at him some more. And Mr. Engels told you he thought the lawyer for Acme was nicer to him than his own counsel. He had no strategies to deal with what is a difficult and nerve-wracking experience. Even experienced lawyers get nervous before examinations for discovery. Ms. Engels did nothing to prepare her client to testify, and if he performed badly at those examinations for discovery, it was her fault. That's where I start.
Okay. Partner now here for counsel for the defense.
So before I start, I'm going to take 15 seconds to tell you what I'm trying to do here. So we're just doing a little snippet from our examination, and I'm on for Cooperman, and I know, and I'm going to talk about the issue of the conflict between the passenger and the driver. And I know I have a lot of problems with whether or not they explain properly the comparative negligence regime. So what I want to try to do is put a lot of emphasis on something that I think I have a stronger defense on, which is even if Mr. Engels had been told of that, so it's a causation issue, he still would have waived the conflict, because I think my evidence is better on that. And then depending on whether I get through the 7 minutes, I'll spend a few minutes speaking about the tougher issue, which is whether or not they explained it to him carefully. And I'm going to try not to break things while I'm reading. So in September 2008, when Mr. Engels walked into the Cooperman and Jones law firm, he blamed the Acme truck driver for everything that had happened to him. For the broken ribs, for the broken arm, the hip, the leg, his knee injury, his medical expenses, and for his lost income. In fact, the one thing Ms. Parker and I agree on is that the first time Mr. Engel was hurt, he was hurt because the Acme car driver sideswiped Ms. Rubin's car. And it was the Acme truck driver who hurt him and caused him those injuries. All right, so here's the thing. What did Mr. Engel tell us on examination, cross-examination, about his views of litigation? He told you he wasn't a litigious guy. In fact, when he walked into the office of Cooperman and Jones, he really had gone there because his friend had asked him to. He had no intention of suing anybody. In fact, he didn't even want to sue the Acme truck driver. And why is that? He was in a great deal of pain. He didn't know the Acme truck driver. He had no relationship with Acme. They had never met. They were not friends. They were not acquaintances. In fact, they were complete, utter, and absolute strangers. Right? Yet, he did not want to sue them. In fact, you remember his testimony. Mr. Engel said one of the reasons he didn't want to sue is because he didn't want the truck driver to have to pay his damages personally. Think about that. He was hurt. He only blamed the Acme truck driver, not his friend, for the accident. And he didn't want to sue the truck driver. And why is this important? It's important because what Mr. Engels now, several years later, is trying to have you believe is simply not credible. He is trying to have you believe that he who could not sue a stranger for his broken bones and lost income was willing to sue the woman he worked with day in, day out as a teacher, his old classmate, and his good friend, Mary Rubin. No way. No way. As sure as you are sitting here today, you know that David Engel would not have agreed to sue Mary Rubin, and not under any circumstance. So what else do we know about David Engel's decision to waive any claim against Mary Rubin? Well, you've heard Ms. Cooperman's testimony today as well. And, you know, there's good reason to believe Ms. Cooperman. She's a lawyer who's had 17 years of practice. She has a high volume practice, and by all accounts, she's a hard-nosed, excellent litigator who gets great results for her clients. And she could not have had, and remember, those are not the words of Harriet Cooperman. Those are the words of the infamous or famous Mr. James Storm. Those are the words of the plaintiff's own expert. And Harriet Cooperman could not have had that success. She could not have represented hundreds of clients if she didn't have a good, not just a good and reliable system in place, which ensures, one, that she properly advises all clients of their rights and obligations, and two, that she ensures that she discharges her obligations properly. The Cooper and Jones system at the time was a good and reliable system. It was followed all the time, not just by Harriet Cooperman, but by Pat Simpson. And they told you about that system. What did that system consist of? It consisted of this: a detailed discussion with potential clients about the conflict between the driver and the passenger in the car accident. And in that discussion, the clients were always told two things. First of all, if the driver was found to be partially at fault, failing to sue the driver could reduce damages for the passenger. And Pat Simpson told you that more often than not, she gave an example to illustrate the point. Remember, she described that example to you? She called it the 90-10 example. Both Pat Simpson and Harriet Cooperman followed the system when they met with David Engels. That's what they told you today. When Pat Simpson met with David Engels, she explained the conflict to him. David Engels even admits this. He admits, at least, that he was told that he had a case against Mary Rubin, that he had a right to sue her, and he was given time to think about it. Having been told that he had a right to sue, he had time to think about it, what decision did he